as a condition of my going into the annual meeting, a shareholder. Now that's Gestapo, as Cablevision is. And I wrote that and various other violations of my rights as a shareholder to the chairman of the SEC. His name is Donaldson, William Donaldson, a handsome man, and I saw his picture in the New York Times. And they just wouldn't respond. You know, they'd send me educational material, which consists of nothing but rationalizations why they don't do their service to the public. They're there for a reason, to protect the public against crooked people in securities. And there are a lot of those. And then I just had to sue them. And so I did sue them in Omnibus 23, which was served, I believe, last week, wasn't it? And I sent back a letter to them on a 9x12 open-face envelope, which is very, very effective. You know, if they don't listen to you, and if they pass it from here, there, and everything, you just send it through the United States mail on the postal trail from New York to Washington, and everybody can read it. So I sent them a letter and said, well, I read it to you. And now I get a letter from them, and this is signed by somebody a little higher up. Aldous Lapins. Dear Glendora, your September 7th letter to Chairman William H. Donaldson about Charles F. Dolan of Cablevision Systems Corporation has been referred to the Office of Investor Education and Assistance. I don't want that, okay? I want an investigation. I told him frankly, I think we have another Enron here. Why would a man in a company refuse to show you the books, records, minutes, and shareholders list 107 times? And why would they go through all of this ballerina of not letting you take the annual meetings? What are they covering up? For review and response, you have contacted this office before regarding various complaints against Mr. Dolan and against Cablevision. In your September 7th letter, we noted your request for an investigation. Oh, that was only in the first letter. The second, the third, and the fourth. Finally, the fourth one they can read. We will carefully consider your request for an investigation, but at this point, that's a victory. We will consider your request for an investigation. In other words, they will investigate doing an investigation. That is a great triumph. That only took like a half a year. But at this point, our office can do nothing further to help you. This is because the SEC, Securities Exchange Commission, generally conducts its investigations on a confidential basis and neither confirms nor denies the existence of an investigation until we bring charges against someone involved. More cover-up. More cover-up. More dishonesty. More obfuscation. More adumbrel. We cannot provide you with updates on the status of your complaint or of any pending SEC investigation. We know this policy can be frustrating, but it protects the integrity. What a lie. And effectiveness, another lie, of the investigative process and preserves the privacy of the individuals. Yeah, they always preserve the privacy of the crooks. If you're a nice person and you do something wrong, or you're accused of doing something wrong, which you didn't, the first thing is they give it out to the newspapers. Preserves the privacy of the individuals and entitles entities involved. I've attached a flyer that describes our policy more fully. Let me just go back to the next two sentences. How are they going to keep the investigation secret from me when I'm the person they've got to call to get the information? So let's address this. I've attached a flyer that describes our policy more fully. Thank heaven, he didn't include it. I don't want to read it. It's just more rationalizations why they are not serving the public. We appreciate the opportunity to review your concerns. We will add your recent letter to your file. If you have any questions, please contact S. Philip Neri, or Neri, N-E-R-I, of my staff at 1202-942-7040. Sincerely, Aldous Lapins. Well, Mr. Lapins, what I'm reading now on television will be on the internet, and I think it will be on program 3912, second edition. And now, let me read you the open-faced letter on a 9x12 envelope sent to Donaldson, the chairman of the Securities Exchange Commission, Dolan, Charles F. Dolan, and John Tata. I want to speak to you more fully about John Tata later, okay? The Center for Judicial Accountability Incorporated, Mr. George McDermott, tremendous American hero in Washington, D.C., to you, the Glendora TV audience, the all-important, and to the internet audience. And to everybody on the postal trail, New York to Washington, D.C., and in the Who to Sue file, folder, envelope, 3 sets, and to George Bush. We'll remember in November. This is Opus 1215. It took 2 hours and it cost $5 to print and post. October the 14th, the year 2004, Anno Domini, the year of our Lord. Thank you for stating you would investigate the probability of investigating. Charles F. Dolan and Cablevision. This is a tiny step for mankind. Remember when the astronaut stepped on the moon and said this is a big step for mankind? Charles Dolan has refused to show the shareholder list, books, minutes, and records to shareholder Glendora 107 times and exclude her from shareholder meetings unless she signed an affirmation she would not tape nor ask anyone else to tape the meeting. You know what I should do? You know, I played that tape on the TV, and they really looked so bad. It was on D-Day, and I think it was 2001. And I played the whole tape, the audio tape, on the TV. And it took a long time, like a half an hour and then another half hour. And it was after that that they came out with this. I don't wonder they didn't want it on TV. It was so bad, and the annual meetings are always bad of Cablevision. But you know what I should do? I should get out that program. And I should play it on TV again. And I should play it on the internet again. Now what is he covering up, Glendora asks. Glendora suspects we have another Enron here. It has taken nearly a year to awaken you people to this. Your letter received last week is the first glimmer that you might do what the people appointed you to do. You say, quote, our office can do nothing further to help you, quote. Well, your office has done nothing to help me so far. And further, you are not helping me, you are helping the United States of America. How can you deny the existence of an investigation when you have to talk to me to do an investigation? Enter herein a small reminder, we are not a police state, we are a republic. We are a free and open society. Your solicitude of lawbreakers evokes no sympathy. It's the integrity of America that must be protected. You said you attached a flyer. You did not. Well, I'm glad you did not. These rationalizations for not performing your duty to Americans wearies us. If I have any further questions, I will contact the chairman, Mr. Donaldson, not Mr. Neary. The chairman has ultimate responsibility. Over the months, Glendora, upon information and belief of her 11-year investigation of Dolan Cablevision, it will be 11 years, folks, on Armistice Day, Veterans Day, November the 11th, less than a month away. Glendora, upon information and belief of her 11-year investigation of Dolan Cablevision, that another bad actor behind all this defiance of the New York State Business Corporation Law and the Delaware Law of Corporations, by the way, that's interstate, making it a federal case of citizenship, diversity of citizenship, is John Tata. Tata may be the silent man at the top who mandates these cascades of violations of shareholder rights, together with promiscuous violations of Glendora's public access rights, Title 47 U.S. Code, Section 521 et sequitur. Now what you read here will be read on TV and on the internet. Your estimated program number is 3913-3. Well, I missed it by one. There's a joke about that. Your debut will be circa mid-November. At election time, we remember in November. Blessings richly upon you, yours in truth and in amor patriae, Glendora, without prejudice, Uniform Commercial Code, Volume 1, Section 207, Glendora. And A Chat with Glendora is on 45 TV stations, 450 municipalities, including Washington, D.C. And www.achatwithglendora.com. I'll tell you that joke. The college football coach went to the college mathematics professor and says, "You've got to pass my star player. Without him, we're not going to win." And the mathematics professor said, he said that 7 times 5 is 33. And the coach says, "So, you only missed it by 1. Okay. I have to make a note of that, folks. SEC, we have to keep this log. This log goes on the internet so that people, when they go to the internet, they can look down the contents and see their name and see what program they're on. So we had Glendora, a cheerful look at life. And then we had the SEC investigation of Dolan Cablevision. I have a story here to read you that I think is terrific. I could hardly wait to read you. And I never can find Daniel in the Bible. It's way up there. Ezekiel, Lamentations, Jeremiah. It's right around here somewhere. And it's the first chapter, and it is such an interesting story. I found it! Daniel! tore it out. Don't think that that's sacrilegious, folks, that I tear out pages from the Bible. Because I have a lot of Bibles. They're all over the place, but this is the one that I tear things out of. And it's the book of Daniel, and it's the first chapter, and it's the whole chapter. First chapter 1. It says, in the third year of the reign of, Jehoiakim, king of Judah, Nebuchadnezzar, king of Babylon, he's a famous guy, Nebuchadnezzar, king of Babylon, came to Jerusalem. Glendora demands to know its relevance. Glendora demands sanctions against Caligari for mischievous misrepresentation pursuant to civil practice laws and rules analog to Federal Rules of Civil Procedure, Rule 11. It is clearly an attempt to prejudice the court against Glendora, and any court so prejudiced must recuse pursuant to civil practice law and rules analog to Federal Rules of Civil Procedure, Section 144 and 354. Caveat, court, caveat. Final objection. Caligari's list is incomplete. He does not list all of Glendora's brave fights for rights, fights for Americanism. Caligari does not include in this affidavit list an affidavit by E. Cox, and that's more error. Affidavit is a nothing, it's bulk, it's no weight, and it's billable time. Again, what does it prove? It is billable time. And this is dated October 11th, 2004. Columbus Day. Sick. Columbus Day is October 12th. County of Columbia. How are we doing, folks? We're up to page 27, and this is Caligari's affidavit, and he says the attached hereto as Exhibit A is a true and correct copy of the Glendora's claim dated June 11, 2004. What?
Welcome to a chat with Glendora, America's champion of pro se litigants' rights and First Amendment rights. Stay tuned, we will be right back with our show.
What do we want? Justice! When do we want it? Now! Who are we? A court! What do we want? Justice! When do we want it? Now! Who are we? A court! What do we want? Justice! When do we want it? Now! The people!
Justices and clerks of the state courts in New York, federal, district, and circuit court justices and clerks and justices of the United States Supreme Court. So what's the relevance? Naturally I have, because they broke the law. And if they don't want these cases, then don't break the law. And what law is broken? That Glendora brings cases against people who break the law, whether they be judges or justices or clerks. Callaghan says attached here too as Exhibit B is a copy of the search results for the following searches. A search of federal decisions for cases with the name Glendora is the parties, which yields a list of 88 decisions. Relevance? A search of federal decisions with the names Glendora and Cablevision, which yields 16 federal court decisions. Good. And total search for the name Glendora in New York State cases, which yields a further 28 reported state court decisions. So what's that add up to? About 110? Callaghan never answered the Harrison court. I sued Callaghan in the Harrison court. And I sued Callaghan in the North Carolina court, and he's never answered. And right now, he's in the Fourth Circuit of the U.S. Court of Appeals in Richmond, Virginia. Now this is IOTA, and we're on page 29. Glendora addresses the Callaghan Memorandum of Lawlessness and motion for summary judgment. Defendant Deborah Eacock, through her attorney Sadly Stevens Burke and Burke, respectfully submits this memorandum of law in support of her motion to dismiss the claim of the plaintiff Glendora, or alternatively for summary judgment. And Dum Callaghan can't get the name right in a caption, and he never could. He never gets the name right of the plaintiffs. He never gets the name right of the defendants. Glendora is adamant about this. She must be addressed by the name in the caption and not by any name after that, or she will address Callaghan by his other name, Flyer for Hire. Glendora regrets this has to be the first point that she makes. The second point Glendora makes is that she does not believe Robert Callaghan is Eacock's lawyer. She wants Carmody weight proof that he has the authority to represent Eacock. And if he does, Glendora wants to know if he is pro bono and did he solicit the business. Mighty Park Avenue lawyer sinks to a small claims court again. The result of this is a Bragdonagnian trying to fit into a Lilliputian court. It's an acre trying to fit into a square foot. As Abraham Lincoln said about General McClellan, I've never seen so much shuck for such a small nit. Also, what Abe said about McClellan applies herewith. He's got the slows. Glendora takes exception to Callaghan's nescience, bringing Park Avenue litigancy to small claims. Right, folks? This is his third offense. Rye City Court, where he lost. Harrison Town Court, where a judge is in the hospital. And now Phillipstown. Glendora objects on the following grounds. Read what Hudson County Supreme Court ruled on another small claims that Glendora is jubilant about. This is from Jonathan Nichols, Judge, Supreme Court, County of Columbia, where Glendora appealed George Dixon's dismissal of her case against Nasty Natalia and her brat sister, and against Preferred Country Properties et al. And Glendora won the appeal. And it says, the pertinent facts as to the instant matter are relatively uncomplicated. The appellant filed a small claims action against the respondent, that would be Preferred Country Properties, and in conformity with Uniform Justice Court Act, 1803, the clerk of the village court prepared and mailed a return, small claims to the respondents, and on April 13, 2004, appellant and respondent appeared in the village court of Chatham. At that time, appellant filed a document entitled Glendora ad damnum, supporting to set forth her particular damages relative to her small claim. Thereafter, on motion by respondent attorney, the village justice dismissed the appellant's claim. Based upon the aforesaid, it is this court's determination that the village court erred in dismissing the appellant's claim. The small claim court is designed to allow unrepresented individuals, now that's not Callaghan and Ecott, untutored in the formalities of the law, to pursue claims in a simplified setting, free from the technical requirements that animate more traditional civil courts. In this regard, the Uniform Justice Court Act, Section 1804, explicitly states that small claims courts shall not be bound by statutory provisions or rules of practice, procedure, pleading, or evidence. Indeed, the statutory mechanism
Just a minute.
the statutory mechanism, isn't that what he said? Commencing a small claims action evidences the unique relaxed nature in the small claims court, inasmuch as it dispenses with the need for a summons and a complaint, as the court clerk instead prepares a notice containing a statement of the nature of the claim and hereafter mails a statement to the defendant. And so he goes on saying, very much on our side, folks, that small claims is not the place for a Park Avenue lawyer, with all this stuff about a memorandum of law and all these affidavits. And that is written by John Clark for Jonathan Nichols. And we have reached our quota. We're going to read 20 pages at a time, and then we'll take a break. Why are Bob and Joan the perfect couple? Why are Bob and Joan the perfect couple? He's a hypochondriac and she is a pill. Okay, folks, let's do pages 41 to 60 out of 100. I have the most delicious casserole. You take vegetarian hamburger, you take a big skillet, put your vegetarian hamburger in it, and 2 cans of green beans, drained, and then 2 cans of tomato soup, and a half of a teaspoon of ground cloves. That is the most delicious casserole, and you serve it underneath mashed potatoes. Put mashed potatoes on top. Great meal. The woman says, I have the most delicious recipe for casserole. I simply mention it, and my husband says, let's eat out. In summary, Glendora asked for judgment that her small claims rights are being violated. Legal basis is the Uniform Justice Court Act and the Small Claims Act. It'll be section 1801 et sequitur. Now, Callaghan says, the alleged facts relevant to this motion are contained in Glendora's claim, a copy of which is annexed to the affidavit of Robert M. Callaghan, sworn to September 23, 2004, with exhibits annexed thereto, Callaghan affidavit, and the affidavit of Deborah Ecott, sworn to September 23, 2004, with exhibits annexed thereto. ECOC affidavit, both submitted herewith. There's nothing so simple a lawyer can't make it difficult. The defects of which Glendora has scrutinized and abundantly delineated. Preliminary statement, says Callaghy. Before the court is professional pro se plaintiff, in quotation marks, Glendora, who over the years, well, Glendora says, when a lawyer makes a quote, he has to give a source. So who said Glendora is a, quote, professional pro se, quote? Is it the professionals this pro se has beaten so many times like Callaghy? It's easy to beat lawyers. Why would a memorandum of law lead off with an ad hominem? Glendora has sued Callaghy in many courts. He is a professional defendant, a man who has violated the professional code so promiscuously he has been debased as a defendant. Presently, Callaghy is a defendant in the Town Court of Harrison, Westchester County, in the United States District Court, Raleigh, North Carolina, and in the United States Court of Appeals for the Fourth Circuit, Richmond, Virginia. His evil in the Rye City Court is now on appeal in the appellate term, Second Department, 9th and 10th Judicial Districts, Brooklyn. And did Callaghy ever tell that to ECOC? Does she know this about him, how bad he is? He does not come to you with clean hands. Says Callaghy, has made a practice of bringing harassing lawsuits against numerous defendants, including state. Well, Glendora says A. Callaghy memorandum lie numbered 1. B. This is conclusory. C. It is vexatious. D. This belongs in a memorandum of law. It should be in an affidavit. Park Avenue lawyer needs a refresher course, says Callaghy. And city employees, justices and clerks of the state courts in New York, federal district and circuit court justices and clerks, and justices of the United States Supreme Court, many of, Glendora says, this is rank intent to prejudice and bias. Now, if this court is influenced by this below-the-belt swat, the court must instantly recuse pursuant to CPLR, Civil Practice Laws and Rules, analog to U.S. Code Title 28, Sections 144 and 354. You have to recuse if you're biased or prejudiced, and this is what Callaghy's trying to do to this judge. It is also repetitive. He has said this in this bulk paper before, all bulk and no weight. What law does Glendora's hard work imploring the courts for justice break? What law does it break? You can't go to court. You're not supposed to go to court. You're not supposed to use the courts. He could rather, Glendora would punch the lawbreakers in the nose. That's what you're supposed to do. Instead of taking the party to court, you're supposed to go out and punch them in the nose. It's against the law to seek justice in the courts. Callaghy is being redundant, vexatious, and scheming. He is batching himself with the lawyer Shakespeare so ably characterized, the archetype. Do you know the name of that lawyer in the Shakespeare? I think it's in The Merchant of Venice. Can you think of that? Well, it finally came to me this morning. Shylock. Remember Shylock and the Pound of Flesh? The archetype of the lawyers that we know today. Says Glendora, Callaghy tries this in every court and fails every time, but it is all he knows how to do it, so feel sorry for him. Glendora could list 8 pages on him trying to win with his alphonsus. Now, Callaghy says in a footnote, the United States Supreme Court has gone so far as to prospectively bar Glendora from informer paupers filings in non-criminal cases, based in part on her previous 14 petitions, all of which were denied without dissent. See Glendora versus Porzio, a bad landlord. Well, that tells you more about Glendora, about the Supreme Court of the United States than it does Glendora. The Supreme Court of the United States is not like poor people. If you're poor, you're not supposed to go to the Supreme Court of the United States. Well, Glendora says, if this is such an important point, why did you relegate it to a footnote? Can't you write a paper, Callagy, without footnotes? Cannot you write an integrated paper without disjointed footnotes? No, you cannot write an integrated paper because that takes integrity. Callagy has not replied to Glendora's cross motion in the Harrison court. His time expired August the 17th. What does this footnote tell you? It tells you we have a pretty bad U.S. Supreme Court. It abominates poor people. You can't go unless you have money. And you are guilty until proved innocent. People would, worldwide, on the internet, will be hearing and reading this. And there was a dissent. Kennedy dissented. Callagy always loses on this one. Callagy, page 2. It took 1¼ hours to set the record straight on the damage he did to the record with his page 1. Now Callagy says Glendora's frivolous claims have been directed against CSC Holdings. CSC stands for Cablevision Systems Corporation. Callagy says Glendora's frivolous claims have been dismissed against CSC Holdings Incorporated. And then he puts in parentheses Cablevision, and Glendora says, here are lies by Callagy numbering 6 and 7. Claims against the U.S. Constitution, the New York State Constitution, Article 1, the Bill of Rights, and the statutes such as Title 47 U.S. Code Section 521, the Cable TV Public Access Law, and 9 New York Code Rules and Regulations 595.4, the New York State Cable TV Public Access Laws, and New York Public Service Law Article 11, Section 229, which says no cable operator shall exercise editorial control over public access, which is like a forum in the park, are just the tip of the iceberg. And they are hardly frivolous. I don't call those frivolous, do you folks? And what is frivolous is Callagy's anemic defenses, so-called. Now, Glendora has never sued CSC Holdings Incorporated in her life. This is a bold-faced lie. And this liar ought to know that. I have never sued CSC Holdings. I have sued Dolan and Tata and Kofal and Cablevision and the crooks that work for them, but I have never sued CSC Holdings Incorporated, and he's trying to get the court to make I did. For some reason, he wants all of my cases to be cases against CSC Holdings Incorporated. What do you think his reason is? Glendora says this is willful, deliberate, and knowing misrepresentation, and this liar for hire must be sanctioned $10,000 and sadly an e-car pursuant to New York State analog to Federal Rules of Civil Procedure, Rule 11. Callagy says its officers and employees in connection with Glendora's public access cable television program, A Chat with Glendora. Glendora says this is further misrepresentation. The point being that they weren't always about the public access program, although many of them were, because Charles Dolan and John Tata and Cablevision have tried to keep it off of the TV, and they haven't been able to because of my actions against them in the court. But they weren't all about public access. Many of them were about Charles Dolan refusing to show shareholder Glendora the books, records, and minutes, and the shareholders list. 107 times. Many of them are against their violations of the New York State Business Corporation Law and the Delaware Law of Corporations. So that's another lie by Callagy. And so herein I include the letter that I got from the Securities Exchange Commission, where I have addressed as chairman, William Donaldson, 4 times that I want an investigation of Cablevision. I think it's an Enron. And I want them to, why would a man refuse to show you the books, records, and minutes and shareholders list 107 times? And why would a man make you sign an affidavit as a condition of going into the shareholders meeting? Sign an affidavit that you will not tape it, or that you haven't asked somebody else to tape it. What are we covering up? So I wanted it investigated as an Enron, and I enclosed this letter from Aldous Leapins, saying that they will investigate the possibility of an investigation. I read that to you yesterday. Set the record straight. Glendora has sued Cablevision Systems Corporation also for violations of the New York State Business Corporation Law and the Delaware Law of Corporations. Dolan Cablevision refused to show shareholder Glendora the shareholder list, books, records, and minutes 107 times. Finally, by suing Donaldson and the SEC, she has got a commitment from them that they will investigate Dolan and Cablevision. Glendora intones, we have another Enron here. Why would Dolan refuse 107 times to show Glendora the shareholders list, the books, records, and minutes? Why? Glendora also sued the Dolan Cablevision Conclave for being a RICO, racketeer influence crime organization, for violating New York State and Delaware business law in 2 federal courts. But the federal courts dismissed pro se in former paupers cases as a matter of conditioned reflex. What does this have to do with Deborah Eacock breaching faith with Glendora and causing Glendora all this time, money, and labor to find a new signer? Nothing is the answer. And Callagy is doing his usual obfuscating and adumbrating. If Eacock were smart, she would not pay him for his attempted derailments. In the meantime, Glendora applies to the court for sanctions of $10,000, mentioned super, for not dealing with the issue. Callagy's mommy and daddy wasted huge dollars sending him to law school. James Burness. His papers are as dull as dishwater. Indeed, Glendora is provoked with Eacock siding with the cheater enemy, Cablevision, but her lawyer aggrieves Glendora more. The lawyer is worse than the defendant. She chose a bad lawyer, and when he solicited, she should have turned him down. It's all he has, folks. He's at the bottom of the barrel. He is not defending Eacock. He has no meritorious defense. And on that basis, the motion to dismiss must be denied. And Glendora must be granted all the relief that she sought in her complaint. Now, still on the Callagy and Beecher, page 2, Callagy says, in order to take advantage of local public cable access, a producer such as Glendora must either be a resident of the service area or have a sponsor who resides in the area. Then Glendora says, who says? What is your statutory authority? What statute in the law in the state of New York or in the United States of America says that so? What? The New York State Public Service Commission does not say so. Callagy is lying again. He says Glendora has now resorted to suing for an alleged breach of contract private individuals such as Miss Eacock, who signed on to act as her local sponsor, but later withdrew the sponsorship. Eacock is sued for giving Glendora her word she would sign and going back on it. Callagy says Glendora's claim has absolutely no legal support, and Glendora says, where is your proof? Callagy says it is being brought solely to harass MS Eacock. Glendora says, proof demanded. And Callagy says, and by association Cablevision. And Glendora says, that's conclusory, and there's no factual basis. And therefore, it should be dismissed. And Glendora says, he hasn't stated a meritorious defense as yet. Glendora does not have to sue Cablevision indirectly. She can sue Cablevision directly, and she will and has. How many times? sued. I sued Cablevision 20 times. Callagy says, alternatively, this court should grant summary judgment in favor of defendant because there is no genuine issue as to any material fact, and therefore MS Ecock is entitled to a judgment as a matter of law. Well, there is a genuine dispute of facts. Summary judgment cannot be granted when there's a dispute of facts. Callagy must be disbarred for citing unpublished opinions. A, he doesn't know better. B, or he is deliberately deceiving, as is his modus operandi. You're not supposed, and that's what most of these are, they're unpublished opinions, and he cites page after page after page after page. A Park Avenue lawyer should know better. The courts do not want those cited as arguments in any other lawsuit. And they have, of course, no standing in any other lawsuits. Statement of facts, says Callagy, Glendora's numerous suits have been the subject of many decisions in federal and state courts. Who cares? As far as Ecock goes. As an indication of the multiplicity of suits, a search of federal decisions for cases with the name Glendora, and he just repeats himself. You know why he keeps repeating? Because he gets paid by the ounce. Billable time. You're on page 55, I'm happy to report. And Glendora says the courts are unamphibolous about quoting unpublished opinions, and Callagy has been defying them for a decade. And then Glendora says ultra-virus, out of bounds, foul shot. Let's see, I took Latin for 3 years. Virus or virus? V-I-R-E-S. Not a virus like a head cold. That's V-I-R-U-S. Virus. I'm going to say it's ultra-virus. Glendora's case has to be adjudicated in this court, and this court alone. Ecock has to stand on her own 2 feet in Phillipstown. She cannot look over the shoulder and copy from the kid at the desk in front of her. Callagy says, now, here Glendora brings yet another claim based on an alleged breach of contract against MS Ecock as a result of her decision to discontinue her sponsorship of Glendora's program in her cable service area.
Welcome to a chat with Glendora, America's champion of pro se litigants' rights and First Amendment rights. Stay tuned, we will be right back with our show.
What do we want? Justice! When do we want it? Now! Who are we? Acorn! When do we want? Justice! When do we want it? Now! Who are we? Acorn! What do we want? Justice! When do we want it? Now! The people! United! Will never be defeated!
In her cable service area, thereby indirectly implicating Cablevision in yet another frivolous lawsuit. Now wait just a second, how many lies are in that paragraph? 4? So, let's go after them. A, as Judge Bryant would say, don't lead me into that thicket. Callagy again does not understand the issue. Wearily, once again, the issue is that Ecock is sued for saying she would, and she went back on her word. Now that's not what Callagy said. She went back on her acceptance. And the terms were stated. The terms were agreed upon. The contract was made, and audio tapes do not lie. Another no integrity footnote. Glendora says Callaghan also fills her complaint with irrelevant and erroneous claims that the sponsor, and Glendora says, stop the progress and deal with another derailment, obfuscation, a dumbbell. Callaghan says, requirement is improper and has no statutory authority. B, prove irrelevant, Glendora says to Callaghan, and prove erroneous. Would you like to make your living lying? Well, that's what this man is doing. Robert Callaghan, he lives in Rye, and he has some kind of an affiliation with Satterley, Stevens, Burke & Burke, a lawyer for hire law firm at 230 Park Avenue, Manhattan. Footnote, Cablevision's policies and procedure to which the public access user or her sponsor must adhere, Glendora says, who says? Who says? Cablevision? Who's Cablevision? Is Cablevision Congress? Is Cablevision the New York legislature? Is Cablevision the municipality that signed the contract? Glendora says, prove it. Are they in accord with municipal law in the town of Phillipstown? This is rather a monumental issue to relegate to a footnote, wouldn't you say? Says Callaghan, in any event, these allegations are irrelevant to Glendora's allegations against ECOC, a private citizen who has nothing to do with the policies and procedures of Cablevision. Then why did you include them as an exhibit in your so-called motion to dismiss? If they have no relevance, why did you do that? Glendora incorporates her demand for statutory authority herein as if fully stated herein. Cablevision, says Callaghan, provides all of its public users with its rules, policies, and procedures to which a programmer must adhere. Glendora says, who says? Callaghan's footnote just said these had nothing to do with a private citizen. ECOC was never provided with the odious kit at all the time that Glendora and ECOC were conversing. Says Callaghan, the Cablevision Public Access Kit explains to the public access user that if the public access user does not live in the applicable service area, she must find a resident to be her sponsor. The sponsor is responsible for executing and abiding by all of the terms of the access user contract. Who says? What is your statutory authority? And now we come to big lie, number 20, by Callaghan, which the access user or her sponsor must sign in order to have access to Cablevision's facilities and programming time. What is your statutory authority? In the access user contract, the applicant agrees to assume all responsibility for the program. That's totally unconscionable. That would never stand up in court. ECOT cannot be totally responsible for anything I say. Glendora says, who says? And what is your statutory authority? And prove it. Did ECOC ever receive a signed contract by Cablevision? Was there ever an affidavit of service of same? Without these, how could it be a contract? How could such a nullity stand up in court? Says Callaghan, and agrees to indemnify Cablevision for any liability incurred in connection with the programmer's use of the public access channel. Glendora says Callaghan again flops at knowing the law. Title 47, United States Code, Section 521, at Secretary says explicitly that it is the public access producer who indemnifies the cable company. ECOC can't do it. It has to be moi. It has to be Glendora. Glendora indemnifies Cablevision. Section 521 at Secretary makes it pellucid. The only one who indemnifies the cable company is the public access producer. Glendora indemnifies Cablevision. ECOT cannot, and nobody can make her indemnify. But what Callagy is doing here is just what Glendora needs to prove her RICO. Racketeer influence crime organization is what Cablevision is against Dolan Cablevision and Tata. Extortion, 18 U.S. Code Section 1961 et al. Says extortion, an enterprise, Cablevision is an enterprise, and has a money motive. It wants to get rid of the cost of public access, and it wants to use our channel for commercials. And over 100 predicate acts a year. That's required by the RICO Act. Now, I am happy to report that we are up to page 60. So we will take a break, and then we'll come back and do 61 to 80. The girl said to the basketball player, "You smell good tonight. What do you got on?" And he said, "Clean socks." May the words of our mouths and the meditations of our hearts be acceptable unto you, our God, our strength, and our Redeemer. Folks, this is a Chat with Glendora program number 3917, the 7th edition for this 2-week period. Now, that's 3,917. When we get up to the 4,000th TV program, we're going to have a celebration. Are you coming? And you can say a word or two. A football coach describes a football fan as somebody who screams from the bleachers that you called one wrong or you missed one on the center of the interior line, and then after the game he goes to the parking lot and he can't find his car. And the basketball coach said to his players, the trouble with officials is that they don't care who wins. Then the basketball star was asked, which do you think is more detrimental to the game? Ignorance or apathy? And the basketball player says, I don't know, and I don't care. Prestige, said one athlete, is people ask you for your autograph. That's prestige. Another athlete says, no, prestige is the President of the United States sees you and says, hi Bill, how's the wife and family? Third athlete says, prestige is you go to the Vatican, you have your picture taken, it comes out in the newspaper, and people say, who's that next to Williams wearing the beanie? Ed says that the forward on his basketball team, the forward is so slow that if he got caught in the rain, he would rust. And the girl said to the basketball star, you smell good tonight. What do you got on? And he said, clean socks. Marilyn says that her son watches too much sports, too many sports on TV. He watches basketball, he watches baseball, he watches football. She says he has athlete's seat. And another mother said about her son that he had to give up a very, very promising career because of fallen arches. Was he an athlete? No, he was an architect. And springtime is coming and we will be faced with 3 huge surpluses: corn, wheat, and Girl Scout cookies. A man was worried about his 4th daughter getting married. Why? Well, my first daughter married a man from Singleton, New Hampshire, and she had one child. And my second daughter married a man from Twin Oaks, New Hampshire. They had two children. My third daughter married a man from Three Rivers, Michigan, and they had three children. So why are you worried about your fourth child getting married? She's going with a guy from the Thousand Islands. This is Glendora versus Deborah Eacock. She was my signer in Peekskill. And I asked her to renew. She said she would. And then she let Cablevision scare her out of it, and she breached contract with me, and so I sued her for that. And it is in the town court, Phillipstown, County of Putnam, State of New York, United States of America. Callagee is their liar for hire. He's a Park Avenue lawyer, and he says in or about January 2004, I think that should be on or about, Glendora approached Ms. Eacock outside of Cablevision's offices where Miss Eacock had gone to pay her cable bill. Well, it is a lie. Glendora met Eacock on December the 27th, the year 2002. They're only 2 years off. And Glendora has proof. Now we have misrepresentation, Rule 11. Hearsay. Callagee. Glendora asked her to support her cable public access television program, A Chat with Glendora. Glendora did not. Herein, Glendora reprints her refutation of the Eacock affidavit, which I have already read to you. And so we will skip ahead. Our assignment, immediate assignment for this 15 minutes is to read up to pages 61 to 80. Eacock affidavit, which I've already read to you. Remember, Eacock nowhere says she is telling the truth, the whole truth, and nothing but the truth. She'll help her guy. Yeah, we read to that. See, this is also repetitive. Says Callagee, shortly thereafter, Glendora sent Ms. Eacock a one-page form entitled Access User Application and Contract Renewal, thinking that she was simply further supporting Glendora's efforts to get her program on the TV, and so she was. She says on the air, but cable TV is not on the air, it's on the coaxial cable. Ms. Eacock signed the form on January 13, 2004, therefore becoming the sponsor for Glendora's television program in her service area. At that time, Ms. Eacock did not fully understand what it meant to sign the sponsorship form or to become Glendora's sponsor. So you have said, Glendora. Glendora has heard Barrington Parker tell lawyers at trial many times in his swank White Plains federal courtroom, so you have said, so you have said, so you have said. What is the relevance? Eacock did not understand. This is not Glendora's burden. Everything that Callagee says there is hearsay. He has no personal knowledge. And when is shortly thereafter? 6 months? 3 months? Glendora knows the dates and the events. Callagee and Eacock do not. Repetitive. Callagee gets back, he gets paid by the bulk. So you have said. Several months later, Glendora contacted Miss Eacock to inform her that it was time once again to sign the Access User Application and Contract Renewal. By that point, Ms. Eacock had come to understand the implication of her status as a sponsor and the responsibility that she had undertaken. Well, there was nothing there to worry about, and there's nothing there to understand, because it's all fake and phony. It's just a Cablevision bully lie. Ms. Eacock decided that she did not want to be Glendora's sponsor, and when Glendora sent her the form, she did not sign it. Well, what he leaves out here is that Eacock said that she would sign it. This is the issue. You see how he eschews the truth? That's what a Callagee is, a liar for hire. You pay him to lie for you. She did not sign it. Since then, Miss Eacock has received harassing telephone calls from Glendora, and Glendora says all of this was written in Eacock's affidavit, and the dates, the sequence here is all wrong. And would you like to know the sequence? Well, Glendora knows it. Eacock turned coward, Eacock turned renegade. This is just what bully Cablevision wanted and America did not want. Now Eacock, says Glendora, told Glendora, I may sign it. I'll see. This was 3 weeks after she said she would sign it. Glendora fully understood what Cablevision was saying in the fake contract, and she knew it to be totally toothless. Glendora would never have asked Eacock to sign it if Glendora thought that Eacock would get injured by signing it. She got injured by not signing it. Glendora erroneously claims, says Callaghan, that she had an oral contract with Miss Eacock, under which Miss Eacock somehow became forever obliged to the Glendora's local sponsor, with no ability to withdraw her sponsorship. This is a lie. But once Eacock said that she would sign it, and it was only for 6 months, once she said she would sign it, then she had to sign it. Read the New York jurisprudence. Read New York jurisprudence. In New York, an oral contract is as valid as a written contract. Eacock let more than 48 hours go by her grace period to exit. Remember, when you sign something, you have 48 hours to change your mind. Well, Eacock did not take advantage of that. To the contrary, says Callaghan, there is no contract oral or written, another lie, between Glendora and Miss Eacock. It is black letter law that a contract cannot exist where there has been no exchange of promises or performance. We are up to page 71. There was an exchange of promise. Glendora stated the terms. Eacock accepted. This is a memorandum of law. Well, you produce the law. He hasn't cited any law yet. Callaghan says, even assuming for the sake of this motion that all of Glendora's allegations are true and that Eacock in fact promised to be Glendora's sponsor, which Eacock denies, Glendora made no promise, nor did she, and Glendora says, Glendora stated the terms, Eacock accepted, and this is on audio tape. Says Callaghan, render any performance, Glendora did not render any performance in exchange. There is no contract whatsoever between Glendora and Eacock, and therefore Glendora's complaint should be dismissed in its entirety. And Glendora says, what are your grounds? And what are your legal bases? And what are your factual bases? Ad nauseum, says Glendora, there is no law cited, and Callaghan calls this a memorandum of law. Says Callaghan, his argument is that since there was no manifestation of mutual assent between Glendora and Miss Eacock, there is no contract between them, and therefore Glendora's breach of contract claim must fail. So Glendora called out the no, and she crossed out the other no, and she put in prevail. Reading, since there was manifestation of mutual assent between Glendora and Eacock, there is contract between them, and therefore Glendora's breach of contract claim must prevail. Isn't it comical to see a Park Avenue lawyer try to squeeze himself into small claims court? Says Callaghan, Glendora made no promise to Eacock, nor has she rendered any performance for Eacock in exchange for Eacock's alleged promise to act as her sponsor, and therefore there is no contract between them. Well, just Callaghan, you have to stop and think, baby. It's against the law for me to promise to do anything for anybody who signs the application to have my program on TV in a given area. I cannot promise anything to them. I cannot give them anything. I cannot make any consideration. That is against the law. Public access has to be free. No money passes in public access. Glendora says this is adiaphorous. Glendora stated the terms and Eacock accepted. Says Glendora, we have to step now, folks, and we have to stop now, folks, and deal with a disjointed footnote. It would be nice if Callagee could write an integrated paper, but he can't because that takes integrity. Says Callagee in this footnote, because of the lack of an exchange of promise or performance between Glendora and ECOT, indicating the complete absence of any contract between them, it is not even necessary to get to the issue of the adequacy or existence of any consideration for this alleged contract. They get paid by the pound. They get paid for obfuscation. They get paid for being a dumbo. They get paid for avoiding the issue. They get paid for lying. Would you like to make your living that way? And all of you kids of Callagee, do you know where you get the money to have shoes? From lying. You know where you get the money for the food that you've eaten all your lives? From lying. Your father is a liar for hire. And if you're going through school now, where did that money come? From lying. Says Glendora, this cannot be very important. It is relegated to a footnote. Glendora stated the terms ECOC accepted. This is a contract ECOC copped out, and this is a breach. As yet, Callagee has stated no law in the so-called Memorandum of Law. He needs something from the New York State General Obligations Law. So far, he cannot find anything, and he has no statutory authority. Says Callagee, here, even assuming for the sake of this motion to dismiss that ECOC promised Glendora that she would be the sponsor for Glendora's television program, she promised that she would be the signer. Glendora says it does not have to be assumed. It is on audio tape. Audio tapes do not lie. Lawyers and defendants do. Says Callagee did nothing in exchange to render ECOC's promise a binding contractual promise, nor did Glendora promise to do anything for ECOC in exchange for such a promise. Glendora stated the terms and ECOC accepted. And this is Callagee's last paid, praise the Lord, exchange. Glendora promised to pay ECOC money. That's against the law. Callagee might do such a thing, but never would Glendora. Callagee says, or to paint ECOC's home. And Glendora says, oh, ECOC's house needs to be painted? Callagee says it could be a contract between them. Here, ECOC vehemently denies that Glendora promised or did anything in exchange. Thank heaven. I would be in trouble if I had. Thank you. That would be a lie. Glendora does not lie. She will not sell her soul. It's too precious. And Glendora stated the terms and ECOC accepted. And Callagee says, therefore, assuming for the sake of this motion that everything Glendora says is true, under the most basic principles of contract law, there is no contract between the parties and Glendora's claims must fail. And Glendora says Callagee needs something from the New York State General Obligations Law, and he cannot come up with it. He has no statutory authority. Man, you gotta have a statute. We have to stop here, says Glendora, and deal with more Callagee disjointed thinking. It would be philosophic if he could write an integrated paper, but that requires integrity. His English composition construction is as bad as his legal construction, says Callagee in his footnote. Moreover, Glendora has alleged no monetary damages in her complaint, nor could she have suffered any damages based on her allegations. These are both lies. Why would I do that when it was coming out through discovery? And Glendora says A, who says, B, what is your factual basis, C, what is your legal basis, D, it's dictum, and E, it's conclusory. Says Callagee in this footnote, while Glendora has apparently paid the filing fee for claims of over $1,000 and alleges that it has cost me to get a new signer because ECOC breach of contract, she does not set forth any actual basis for any monetary damages, nor does she explain how it has cost her money to get a new sponsor. That will come with discovery. It's already listed here on page 4 that I read to you two programs ago. My addendum. On a small claims worksheet, one is going to print all of that. Well, this fails in acuity. In public access, one cannot promise to do anything in return. That is against public access law. Glendora does not break the law. She leaves that to the defendant and the lawyer. If paragraph 55 super is so important, why is it relegated to a footnote? Glendora's ad hominem and documentation has already been included in this paper long before she got up to call Callaghan's whimper in paragraph 55 super. Conclusion, says Callaghan. Accordingly, defendant Deborah Eacock respectfully, Glendora says it's not respectful when you lie, requires that this court dismiss the plaintiff's claim, plaintiff is Glendora, or alternatively grant summary judgment in favor of defendant. And you can't do that because there's a dispute of facts. You cannot grant summary judgment when there's a dispute of fact. And grant attorney's fees and costs to the defendant, and attorney's fees and costs are not allowed in small claims court. With such other and further relief as the court deems proper. And it's signed by Robert Callaghan. Would you like to see the signature of this liar for hire? And to this Glendora says, she wants to know, who paid Callaghan? Is it Cablevision? Because Eacock did Cablevision such a great favor, keeping Glendora's program off of TV? In the peak scale system? Is it unreasonable that Eacock can pay it? It's unreasonable, isn't it, that Eacock can pay a Park Avenue lawyer? Is Callaghan pro bono? Glendora has a right to know this to prosecute successfully her case. No cover-up can be allowed. Is Eacock an adjunct of Cablevision? What do you think, folks? Callaghan's motion to dismiss must be denied pursuant to civil practice law and rules for failure to state a meritorious defense. Ad valorem, it is 0. Glendora stated the terms, Eacock accepted. Callaghan has no cite from the New York State Statute General Obligations Law, and this is just billable time. We have read up to page 80. Did you hear about the family, folks, that was so rich they bought a boy for the dog?
Welcome to a chat with Glendora, America's champion of pro se litigants' rights and First Amendment rights. Stay tuned, we will be right back with our show.
What do we want? Justice! When do we want it? Now! Who are we? Acorn! What do we want? Justice! When do we want it? Now! Who are we? Acorn! What do we want? Justice! When do we want it? Now! The people! United! Whatever needed be!
Bob said that when he was a kid he was so ugly that his parents never put a jack-o'-lantern in the window. They just made him stand in the window. We are going to read the last 20 pages of Glendora's cross motion to deny Eacock's Callaghan motion to dismiss, and also Glendora's motion to impose sanctions on Callaghan and Eacock for misrepresentation, and of course for any other further relief just and proper. Now I put the lights on and the backlight. Now what does that do to the picture? It's not good, is it? Let's take off the backlight. There. Is that better? I think so. Page 81. Kappa. Piled higher and deeper. Callagy fails to list any law broken by Glendora. One cannot pay, provide, offer anything to anybody who agrees to be the local resident signing the Cablevision papers for Glendora. That is against the law. So Callagy's argument is a nullity. His paper is crybaby. It is not a grown-up memorandum of law. He does not cite any defense from the New York State General Obligations Law. He has no statutory authority. He has no meritorious defense. Ecox and Callagy states are all wrong. Her recollections are grotesquely erroneous, and Glendora has the proof. Cablevision's rules, policies, procedures have no relevance to Glendora versus Ecox. They have no statutory authority. Even if they did, Glendora is grandmothered. She has been on the Peekskill for years, since 1996. This is long before Cablevision bought the system from Media One, AT&T, who bought it from Continental. Not until year 2000 did Cablevision Dolan try to eliminate public access expense and turn the public access channel into revenue, were the odious rules and harassments implemented. It shocks Glendora Callagy can get a secretary to type his dribble. It is dictum and rhetoric, bulk and no weight. If Glendora had such a weak case against Ecox, as Callagy professes, why did Callagy take the case? Glendora really does not understand what is going on with Callagy and Ecox. It is the New York courts do not give Glendora justice on this case. Glendora will find somebody to pay the $300 and take it to the United States Supreme Court as an original action. Dolan Cablevision will be the defendant. Ecox will be the accessory before the fact and after the fact. Dolan will drop out because he will not pay the money to defend, and he can't pay off the judges in the United States Supreme Court. Upon information and belief, Dolan paid off Bryant, DiBiase, and Peter Lane. Nothing Callagy presents absolves Ecox from going back on her word. This is just common ethics. It is common law, and Glendora presents a corpus delicti herself. Glendora, I am an injured body. Corpus delicti. Or delicti, maybe. If people would live by the Ten Commandments, even if they are not allowed on a judge's wall, we would not have all this tumult in the courts. Ecox, do you fully understand the charge against you? Glendora has videotaped and audio tapes that she wants to show to the court. At trial, how many will this court allow? Who ever heard of anybody saying suing anybody indirectly? Callagy's trying to make a case that Glendora is suing Cablevision indirectly. Now, is that stupid or isn't it? This is absurd. Cablevision and Dolan are not defendants. Glendora will sue them some other place. Is suing them some other place, and has sued them some other place. Callagy has no meritorious defense. What he writes is billable time. Was Ecox ever asked to do anything as a signer? Glendora could not give Ecox any consideration for signing. Again, that is against the law, and this paper by Callagy will be helpful in future suits against Dolan and Tata and Cablevision. I'm beginning to wonder if the bad person at there's so many bad people at Cablevision. But if the Satan at Cablevision is John Tata, is he the one that's causing all this trouble, and has ever since 1993, 11 years? Ecox did not deal in good faith. Glendora did. She would never ask anybody to sign anything if it would get the signer into trouble. The Cablevision papers are nothing They could never stand up in court. They have no statutory authority. They are unconscionable. They are not a contract. The signer has never served a copy signed by Cablevision with affidavit of service. What law does it break to go to court and stand up for one's rights in America's rights? Are people supposed to address the government for redress of wrong, or are they to take the law into their own hands and punch the offender in the nose? Callagy lost to Glendora in federal court. Glendora asked Charles Bryan, how much weight are you going to give to Callagy's list of Glendora's other fights for rights? And Bryant said, none at all. Callagy always makes his papers neat and tidy, but it is just gingerbread. They never have law, fact, nor meritorious defense. Glendora sued Callagy in North Carolina. He's in default. He didn't know enough to answer. He has failed to appear in several federal courts. A lawyer should know better. The internet show number for this case is estimated to be 3,916.6. Okay, that's one of them. This one in particular is 3,917.7. And it would be up in 30 days. Callagy must be sanctioned for he must be sanctioned for relying on unpublished opinions. It is strictly a no-no. Callagy makes himself an accomplice and associate in guilt. Callagy tactic is ambush, and this court is a prize. Callagy made over 50 errors and wallows in lies in the Rye court. He never defended himself on any of them, and this case is so simple. Justice is good, injustice is bad. On information and belief, Dolan paid Bryant, de Blasio, and Lang. Glendora was winning in all courts, and Dolan was cornered, and when Dolan is cornered, or Dolan or Tata is cornered, he gets out the wallet. Callagy still owes Glendora $110 plus 9% statutory interest for the audio tape he ordered in the U.S. court, and Glendora gave it. Nor did he pay the 9% statutory interest or the $350 subpoena money he kept for nearly 2 years after Bryant robbed Glendora of her trial. Callagy does not deal with the issue. He's all over the place with Glendora's other fights for rights, with Cablevision's phony policies and affidavits totally erroneous, not declared under penalty of perjury. He and Ecock have to be sanctioned $10,000. We're on page 91. If Ecock were smart, she would not pay him. She may not be paying. It may be Cablevision. Glendora wants Carmody weight proof. 47 is reserved. Page 48. Then he spoke a parable to them, that men always ought to pray and not lose heart, saying, there was in a certain city a judge who did not fear God, nor regard men. Now there was a widow in that city, and she came to him, saying, get justice for me from my adversary. And the judge would not for a while, but afterward he said within himself, though I do not fear God, nor regard men, yet because this widow troubles me, I will avenge her, lest by her continual coming she weary me. And then the Lord said, hear what the unjust judge said. And shall God not avenge his own elect who cry out day and night to him, though he bears long with them. I tell you, said Christ, that he will avenge them speedily. Nevertheless, when the Son of Man comes, will he really find faith on the earth? And he spoke this parable to some who trusted in themselves that they were righteous and despised others. Now I am the widow, and judge, you are the judge. That's from Luke chapter 17, verse 21. The unjust judge. We enclose here a copy of the notice that you can see Glendora's TV show on the internet at www.achatwithglendora.com. And currently on the internet are 110 Chat with Glendora programs, half hour each. And they are webcast 24 hours a day. And let me just go find the conclusion. Oh boy, the conclusion. Oh boy, what the... Wherefore, therefore, and ergo, Glendora must be awarded the maximum monetary jurisdiction of this court, which is $3,000, payable on November 11, 2004, Armistice Day, together with fees, costs, and disbursements, and any further relief, just and proper, dated October 16, 2004, Anno Domini, County of Columbia, Glendora, without prejudice, uniform, Commercial Code, Book 1, Section 207, Glendora, Opus 1214, 25 hours, $23.68. That's just to write it and get it into the mail. May the words of our mouths and the meditation of our hearts be acceptable under you, O God, our strength and our Redeemer. Verizon is putting a charge on us, folks, to pay something for cell phones. Will you read that and explain it to me? Would you? And when you were, are we paying for, if we don't have a cell phone, are we paying for somebody else's cell phone? It's called portability, taking your number from one phone company to another. No, I've always said that. I never had to pay for that. I've always said that. I would take my number from one phone company to another. From what used to be 9X to MCI, and from MCI back to 9X. So, would you please straighten that out for me? Are we paying a tax on somebody's cell phone if we don't have a cell phone? And do you have anything you want to say? You call me up, please. A Chat with Glendora always has been a good forum for the public. So, and if you're up to your neck in hot water, be like a teapot and sing. We're going over a big mountain. It's beginning to suggest the Berkshires, but we are going to go south. And we are going to go on the Taconic. And we're going through Columbia County, Dutchess County, and Putnam County. And even into Westchester County. to stand up for public access and to protect it from robbers, Robert Callaghy, Deborah Eacock, Charles F. Dolan, John Tata, and Cablevision Systems Corporation. And you are looking at fall foliage. And this is Glendora. I chat with Glendora on 45 TV stations, the Glendora Network, and also on the internet. This is the state of New York, United States of America. We finished the cross motion. We collated it, stapled it, and labeled it. And we reviewed a lot of the papers, not all of them. It's still going on. Guess you'll have to add 5 hours and $5 more. We'll make 32 hours. What? $25 and a whole day. This is where we took the fox out of the road. Poor fox. Just about here, we took the fox out of the road. Killed by a careless driver. All unnecessary. Beautiful red fox. I like that fox. I do not like James Fox in the United States District Court, North Carolina. And I do not like Mark D. Fox, United States District Court in White Plains. And this is the Taconic. And I think this is a very bad crossover. But apparently we made it. Another bad crossover. We are fasting until noon. I always fast until noon. Well, I guess you get the idea, so I'll turn off the camera unless I see an unusually beautiful spot for you to look at. Particularly the old people who have to depend on somebody else. I'll bring the fall foliage to you. This is the Taconic State Parkway. Heading south. Ooh, look at that. It's somewhere around Clabberock, somewhere around Taconic, spelled Taghkanich or something. We're on our way to the Phillips Town Court, Glendora versus Ecock. Glendora asked Ecock to be her signer for a chat with Glendora to be on the Peekskill Cablevision system. Ecock said yes, and then she went back on her word. What scared you, Ecock? What did Cecilia say to scare you? Had anything bad ever happened to you for the 4 or 5 other 6-month periods that you signed? No. This is about the 28th time that Cablevision has done this. Scared away my signers, and they backed down. Ecock Capo. And let me tell you, anybody else who does it is going to get sued. If you give your word, you keep it. Cablevision, you stop extortion. That's you, John Tata, and you, Charles F. Dillon, and you, Christine Savarino, and you, Cecilia Mastrobilli. Out of their evil comes good. Showing you the foliage along the Taconic State Highway. And the luxury of the Lincoln. Ancram, Hudson, 10:45. What are we going to rejoice about? The beauty. For the beauty of the earth, for the glory of the skies, for the love which from above, over and around the stars. Lord of all, to thee we raise this our grateful praise. 82. 11 o'clock. Time to rejoice. We thank Deborah Eacock for all of the 6-month periods that she did keep a chat with Glendora on TV in Peekskill. We've been 38 miles. Where are we? Oh, somewhere around Connick, New York, I guess. We're leaving Dutchess County, we're leaving Columbia County, entering Dutchess. We're about 150 miles from where the World Trade Center used to be. And now our assignment is to go past Pine Plains, Stanford, and Pleasant Valley. And to rejoice without ceasing. That's 45 pure cuts. Are you ready to go, folks? Okay, pull out. Pull out gracefully in the Lincoln. Press resume. 50 miles an hour. Dutchess County. Pine Plains is next. Why doesn't it rain and get it over with? Linger in clouds for 5 days. Give us that beautiful azure blue sky. It's almost cobalt blue. It's better to look at the foliage when the sun is shining, isn't it, folks? See how nice that blue sky would be. Look, right up there. Isn't it nice? Those recalcitrant clouds. Rain and get it over with. And give us 3 days of sunshine. Come, ye thankful people, come, praise the song of harvest home. All is safely gathered in, ere the winter storms begin. Water maker doth provide, for our wants to be supplied. Come, thankful people, come, praise the song of harvest home. That's our joy for 11:15. Every 15 minutes we rejoice about something. Would you like a cup of coffee? I'll buy you a cup of coffee.
Welcome to a chat with Glendora, America's champion of pro se litigants' rights and First Amendment rights. Stay tuned, we will be right back with our show.
What do we want? Justice! When do we want it? Now! Who are we? Acorn! What do we want? Justice! When do we want it? Now! Who are we? Acorn! What do we want? Justice! When do we want it? Now! The people! United! Will never be defeated! 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 The people! United! Will Acorn! What do we want? Justice! When do we want it?
Okay, we've been 50 miles. We left at 10. An hour and a quarter. pray for Callaghy, Park Avenue lawyer. He called the court, asked the court if he had to appear. Because he hadn't received my answer. We're running out of tape. Now, it was so simple. I could have picked up another tape off of the top of the monitor. Well, we passed Route 301, which is the road to the court. The road to Carmel. Stay tuned for Peekskill Hollow. I had to erase some of the beautiful footage I made for you so as to get Peekskill Hollow. My skunks don't go out into the road. They have plenty to eat. Last night I gave them 2 bags of microwave popcorn, 4 pumpkin cookies that they didn't like, 3 peanut butter sandwiches all cut up in little pieces the way they like them, peanuts, roasted peanuts. Like there are some other things. The white one was there. She's beautiful. She had just a little tiny black spot on her back. Beautiful white plume. Keep the plume away from you though. Hills and curves. They're beautiful, but they're hard driving. This must be Peekskill Hollow. Peekskill Hollow Road. David Yort. He was a signer for a chat with Glendora for many months in the Yorktown system. And so, we're on the other side of the hollow. much traffic down here. Up where, on the Taconic where I live, you see one car now and then, if any. We are, by the way, in Putnam County. And after that, Strawberry Lane, where the Unitarian Church is, in Mohegan Lake. And our friend Mary Ramage, who is the signer for A Chat with Glendora in Yorktown. Taconic, Yorktown construction. And it's as bad as ever. Well, we've left the Taconic and we're on Federal Route 6. Mahopac